Ladies and gentlemen, thank you for joining us today and welcome to our firm's Investing in India program and the ninth webinar in this series. My name is Vinay Joy and I'm a partner in the firm's Employment, Labor and Benefits Practice Group. I would like to extend a very warm welcome to every one of you, wherever you are in the world. Investing in India uh, is a webinar program curated especially for existing and prospective foreign investors in India and their advisors to enhance their understanding of key issues in doing businesses in India. The program seeks to cover over time all issues of interest to our target audience. India has one of the largest labor forces in the world with over 500 million people. Over the past decade, we have seen India steadily evolve into a global powerhouse, especially in sectors like information technology, business process outsourcing, and various other knowledge-based services. At the same time, the Indian government is strongly focused on transforming India into a manufacturing hub driven by initiatives like Make in India. This dual growth, both in high-end services and core manufacturing, brings its own unique employment needs and, of course, regulatory challenges. From a global perspective, foreign direct investment into India continues to be strong. India regularly ranks amongst the top FDI destinations worldwide. But with that capital comes increasing scrutiny, especially around labor governance, transparency, and compliance. Multinational companies and foreign investors are particularly cautious about employment-related risks. These include workforce management, which includes performance management, termination and inquiring into employee misconduct, classification of employees versus contractors, and navigating compliances across different states and statutes. Today's session is designed to help demystify this landscape to the extent possible. We'll walk you through the regulatory framework, outline some common challenges, and offer practical strategies for foreign employers looking to operate in India. On this slide is the agenda for today's program. If you do have any questions, please submit them using the facility provided in the webinar portal. If we do not cover questions during the webinar, we will respond offline by email after the webinar. Also, please note that a copy of the presentation, summary notes, and a recording of this webinar will be sent to you after the webinar as a matter of course. Let me now introduce our speaker for today. All registered participants should already have received an email with the resume of our speaker and myself, so I will keep the introduction brief. Our presenter today is Anshul Prakash. Anshul is a dear friend and is a partner with the Employment, Labor and Benefits Practice Group at our firm and is one of India's leading employment lawyers. He brings 2 decades of experience advising employers on the full spectrum of Indian employment law issues, both contentious and non-contentious. He is known for his practical, solution-oriented advice and has worked with clients across industries, from startups and MNCs to promoter-led businesses. Over to you, Anshul.
Many thanks, Vinay, for the kind introduction. It's my pleasure to be a part of this webinar. Before we dive in, here is a quick overview of what we will cover today as part of this session. We will start with a broad overview of India's employment law framework, looking at how laws are made and enforced at both federal and state levels. Next, we will discuss employee classifications. This is a critical area, especially for foreign employers, as legal rights and obligations often depend on how an employee is categorized. We will then move on to employee benefits, where we will distinguish between what's statutorily mandated and what's typically offered on a contractual basis. Following that, we will touch upon employment documentation requirements. This would include offer letters, contracts, and workplace policies, all of which play a key role in legal compliance and setting expectations. Finally, we will wrap it up in the section on common employer pitfalls based on our experience on advising multinational corporations. We will, of course, highlight recurring challenges and how to avoid them. Next slide. Now, employment law in India is governed by a complex and layered legal framework. Unlike some jurisdictions where employment laws are centralized, in India, both federal government and the state governments have the constitutional authority to legislate on matters relating to employment. As a result of that, we have a combination of over 50 federal laws along with numerous state-specific laws, many of which apply simultaneously and need to be harmonized by employers. India's labor laws are traditionally employee-friendly. The legal system tends to prioritize job security, welfare benefits, and protections for employees. So, while this serves a strong social purpose, it also means that employers often face stringent procedural requirements, particularly around termination of employment, disciplinary actions, and compliance with wage and welfare obligations. Now, while the government of India has made significant efforts to boost the ease of doing business in India, particularly to attract foreign investment and support the Make in India initiative, the labor law landscape in the country has seen partial reforms. Several structural and procedural complexities still remain, and from that viewpoint, especially at the state level, the proposed labor codes are yet to be fully implemented. So, against that backdrop, many legacy statutes in India continue to operate in parallel. Moving on to the landscape of the laws, on the left side, we have listed some key central legislations, such as the Industrial Disputes Act, which is primarily relevant in case of employee exits, transfer of employees, and also governs the resolution of industrial disputes and conditions of service. Factories Act, which focuses on health, safety, and welfare in manufacturing establishments. Payment of Gratuity Act, which provides for terminal benefits to eligible employees. And the Employees Provident Fund Act, which is the primary social security legislation in India. On the right side are examples of laws that vary across states. These include Shops and Establishments Acts, which differ significantly from state to state and regulate work hours, leave entitlements, holidays, and employment conditions. Labor Welfare Fund Acts providing social security and welfare benefit across state jurisdictions in India. Professional Tax Acts, which impose a tax on professions and trades. And finally, minimum wage notifications, which are periodically updated by each state depending on the job category, zone, and skill levels of employees. So for employers, particularly those operating in multiple states, navigating this dual structure requires careful compliance management. So it's not just about knowing the law, it's also about knowing which law applies and where. Next slide. Let's now turn to a foundational concept in Indian labor law, the classification of employees, and in particular, the distinction between workmen and non-workmen. Now, this distinction is significant because most industrial relations laws in India, such as the Industrial Disputes Act, which I just referred to, apply only to employees classified as workmen. Now, these protections cover termination processes, dispute resolution, retention compensation, and the rights to unionize. Under the Industrial Disputes Act, a workman is someone employed in an industry to perform manual, unskilled, skilled, technical, operational, clerical, or supervisory work for hire or for reward. But importantly, and this is something organizations in India often tend to miss, job titles or designations do not determine workman status. The test is functional. We look at the actual or primary work the employee performs, the organizational setup, and the person's day-to-day responsibilities are key to determine whether an employee would fall within the definition of workman. So even if someone has a managerial sounding title like assistant manager, if their day-to-day role involves clerical or operational work, more of a desk job, they may still qualify as a workman. Now, courts in India have held that an employee may not be a workman if their responsibilities include overseeing project progress in terms of quality and timelines, ensuring regulatory or contractual compliance, manpower planning, cost monitoring, mentoring subordinate staff, or involvement in company level policy or decision making. And that includes matters related to terms and conditions of employment or conditions of service of other employees. Now, these kinds of functions indicate that the role is managerial or supervisory in nature, and thus the outside scope in terms of Industrial Disputes Act, which defines workmen. Another important point that has to be borne in mind is that managers do not become workmen because their decisions are structured by processes and approvals. Absolute autonomy is not the norm in managerial decision making, nor does the law insist on absolute discretion or absolute autonomy for a person to be a manager. For instance, let's consider the case of an employee, Mr. A, who has a team of 5 people reporting to him. Further, Mr. A reports to the CEO of the company. Now, in this case, Mr. A would be seen as a managerial employee engaged in an administrative capacity, even though he himself reports to another individual, that is the CEO in this case. Now, this is because such reporting to the CEO does not take away the managerial and supervisory role which Mr. A performs in the organization. Now, what about senior executives or senior white-collar employees as commonly referred to? They are usually classified as non-workmen. Their employment is governed more by contractual terms and company policy, with very limited statutory protection under labor laws like the Industrial Disputes Act. In such cases, termination, compensation, and conduct rules are determined by the employment contract as opposed to the statutes. Now, this classification is absolutely crucial when structuring roles and responsibilities, planning employee exits, or even dealing with employee grievances. Next slide. So on this slide, you can see a quick snapshot of key criteria considered to determine if an employee is a workman or non-workman. The first determining criteria is the reporting structure. A supervisory employee has people reporting to them, not just helping them. Imagine a senior software developer who has a subordinate developer assisting with testing. That doesn't make the senior a supervisor, but a team lead conducting one-on-ones and delegating projects. Yes, that's supervisory. Next is authority and direction. Managers can allocate work, decide on who does what, and direct how tasks are performed. This is beyond saying do this or do that. It's about setting priorities and ensuring outcomes. Another important point is leave and appraisal authority. Approving leaves, handing appraisals, and recommending increments are key indicators of management. So if you can shape someone's growth or deny their leave entitlements, you're not just a peer, you are a supervisor. Disciplinary and termination related authority. Managers can discipline or even terminate the services of employees, or at least recommend those administrative or disciplinary actions. Strategic input and policy making. If someone is involved in business plans or influencing policy that's beyond operational execution, that amounts as a managerial function. Accordingly, it's the key to remember that it's not just about title or designation. It's about functional authority. Just supervising someone doesn't make you a manager unless the person has the real authority to direct, influence, or decide. Next slide, please. Now, why does this classification of employees matter? Because workmen enjoy significant statutory protections under Indian law, particularly under the Industrial Disputes Act, which has been time and again referred as part of the session. First are the termination safeguards. Employers are required to provide at least a month's notice or salary in lieu of that notice before terminating a workman category employee. Additionally, statutory severance compensation must be paid, which is calculated at 15 days wages for every completed year of service. Employers must also give notice to the appropriate government in case of retrenchment. In some cases, such as where 100 or more workmen are employed in a manufacturing unit, prior government approval is also required before retrenching the workmen category employees. Next is protection from adverse changes. Employers cannot unilaterally alter the terms and conditions of employment for workmen category employees. Now, any change such as work hours, location, pay structure, or job roles and responsibilities requires advance notice, and the employees have to typically be agreeable to such changes. In case of business transfers like mergers or business or asset transfer, these are the safeguards to ensure no adverse impact on the employee's pay, benefits, or continuity of service transpires. Lastly, dispute resolution rights. Workmen have the right to raise industrial disputes on a range of issues, from termination of employment to wages or changes in the terms and conditions of service. These disputes can be escalated to labor courts or industrial tribunals, in addition to one approaching the jurisdictional labor commissioner's office, and these are dedicated forums for adjudicating such matters. The possible outcomes in these forums can be quite serious for employers, including reinstatement of the employee, full back wages payment, or even monetary compensation. So in summary, workmen are a highly protected category of employees under Indian labor law regime. Exits and disciplinary matters for workmen must be carried out very carefully and with strong documentation. Non-compliance is not just a statutory violation, but can also lead to significant exposure to litigation risk, especially in sectors with large workforces or prominence of trade union. Next slide. Let's now take a quick look at the key statutory benefits that employers in India are legally required to provide. Now, these are non-negotiable entitlements governed by labor laws, and these apply whether or not they are set out in an employee's contract. Staying compliant is not just about good practice, it's also essential to avoid penalties and legal risks. First, there is the Employees Provident Fund Contributions, or EPF as it is commonly referred to, which is the Social Security contribution. Now, under the EPF Act, both employer and employee contribute 12% of the base wages towards retirement savings. It's mandatory for those earning up to USD 250 per month, but many employers extend it to all employees, which is a common industry practice. There are these two benefits for lower wage employees, that is employees earning less than $250 per month. And these are the employee state insurance coverage, which offers health and maternity coverage funded by employer and employee contributions. Uh, And next is gratuity, which is also a terminal benefit payable to employees who have completed 5 years of continuous service, though this condition is waived in case of death or disability. And what's the formula? 15 days wages for each completed year of service is a major financial obligation that HR and finance teams of all organizations must carefully manage. Now, when it comes to leave entitlements, different laws, including state-specific Shops and Establishments Acts for commercial establishments and Factories Act for manufacturing establishments are in place. And these mandate minimum casual, sick, and earned leave entitlements as well as holiday entitlements. While details vary from state to state and sector to sector, the principle here is very clear. On average, employers are entitled to 18 annual leaves per annum, 10 to 15 casual leaves and sick leaves, and 8 to 10 festival and national holidays. Under the Maternity Benefit Act, eligible women employees get 26 weeks of paid leave for the first two children and 12 weeks from the third child onwards. Now, the law also provides for leaves for adoption, surrogacy, miscarriage, and also mandates creche facilities for organizations with 50 or more employees. And when I refer to employees, it's male and female employees both. It is not just limited to women employees. Lastly, the minimum wages. States in India notify wage rates based on skill, industry, and region. All employees must be paid at least the minimum wage. Next slide. Now that we have covered statutory benefits, let's turn to contractual and discretionary benefits, those that are not mandated by law but widely offered by employers in India to attract, retain, and motivate talent. A key category is equity-based incentives like ESOPs, restricted stock units, and phantom stock options, and long-term incentive plans like deferred bonuses. These are popular in competitive sectors and help align employees' interests with the long-term success of the company by offering ownership or cash-linked rewards. Next, there are various bonuses beyond legal requirements, such as joining bonuses, relocation allowance, retention bonuses, and performance bonuses. Now, these are typically outlined in contracts or company policy and serve as strong levers for productivity and loyalty. Most employers also provide insurance coverage, including health insurance, life insurance, disability insurance cover, and sometimes accidental or critical illness coverage too. Now, these benefits, which are discretionary in nature, of course, add financial security and make the overall benefits package more competitive. On the non-monetary side, flexible work arrangements, remote work, hybrid work models, and flexible hours have become critical in the post-pandemic era. These tend to support work-life balance and are also a key to employee satisfaction. Beyond statutory maternity leave entitlements, employers have been increasingly offering paternity, menstrual, bereavement, and recuperation leave to employees, which tends to show greater sensitivity to employee needs. Finally, investing in employee assistance programs and wellness initiatives, including mental health support, fitness programs, and stress management resources, are becoming commonplace to improve morale, reduce burnout, and enhance overall productivity of employees. Next slide, please. Let's now look at the employment documentation and policies, which are essential for effective workforce management and legal compliance in India. At the core is the employment contract. Apart from transparency around remuneration and benefits, It should clearly outline the employee's role, duties, designation, location of work, working hours, and shifts, so that expectations are set from day one for all the employees. It must also define the tenure, whether the job is fixed term or indefinite, as this impacts notice periods and termination rules. It's also crucial to get the employee's consent for background checks and personal data processing. And this is in line with Indian data privacy regulations. What's key and missing in several employment contract templates which we have come across are robust termination clauses to address exits on account of various scenarios like misconduct, habitual absenteeism, and notice period requirements for situations where there is no cause or termination for convenience situations. Appropriate restrictive covenants like confidentiality clauses, IP assignment provisions, anti-disparagement, which are relevant to the employee's role in the overall ecosystem of the organization, are equally important. Now, when you're using global employment templates, don't just forget to localize them for India and align them with Indian labor laws and practices to ensure that the contracts are not just valid but also enforceable. Next slide. Executive contracts. One of the most key issues which we continue to address from time to time. Contracts with senior executives offer greater contractual flexibility that can reflect the unique nature of these positions. Common clauses you will find in executive contracts include a lock-in period and bonuses or equity-based rewards like employee stock ownership plans or ESOPs as commonly referred to. And these are designed to align executives' interests with the long-term success of the organization. You will also see representations, warranties, indemnity clauses which protect the company by ensuring executives providing accurate information and take responsibility for their actions. Non-compete clauses are often included to restrict executives from joining competitors after leaving the company. Sometimes these come with non-compete fee as compensation during the post-employment restricted period. However, it's important to note that in India, it is a settled position that post-employment non-compete restrictions are not specifically enforceable against former employees, even if there is a corresponding payment involved. However, they are still included in employment contracts for their moral deterrent value and also the financial incentives that executives can avail should they comply with these obligations. Executive contracts would also see more robust and detailed non-solicitation and confidentiality obligations. Finally, executive contracts sometimes also include golden parachutes. These are special protections and compensation packages triggered during a change in control event or termination. And these are designed to provide financial security to executives in uncertain situations. I would also like to highlight that no two C-suite contracts look the same in India. Now, it's a reality which is shaped by who the executive is, who they work for, and what their key goals are. What really works for a promoter will not work for an investor appointed representative. A promoter-led company may prioritize loyalty and long-term alignment. They might tie the compensation to legacy and stewardship, but an investor-appointed CEO will be assessed by very different KPIs like return on investment or exit value. Similarly, a seasoned, well-reputed executive, for instance, someone with decades of global exposure, will negotiate for autonomy, golden parachutes, and board rights. On the other hand, A rising star in their 30s or early 40s might value growth linked incentives and learning opportunities more than fixed compensation. There are also sectoral nuances. A C suite role in a heavily regulated industry like a banking company or a pharmaceutical company may come with compliance heavy obligations, whereas in tech startups, agility and innovation clauses dominate. Therefore, it's the key to avoid boilerplate clauses and ensure that each executive contract is appropriately drafted. Next slide, please. Let's now look at the employee policies, which fall into two broad categories: statutory policies and good to have policies. Starting with the statutory policies, these are legally required, and organizations in India must ensure proper documentation and compliance. A key example is the anti-sexual harassment policy, which is mandatory under the Prevention of Sexual Harassment at Workplace Act in India. Employers must set up an internal committee with members drawn in from within the organization at every location with 10 or more employees. It is also required to be noted that IC must include an external member. The internal committee members must be trained, and the internal committee as such is required to be registered on the appropriate government's she-box portal. Now, some states also require registration with the local district authority. Next, the maternity leave policy should fully reflect entitlements under the Maternity Benefit Act. Companies are now required to report compliance and disclose the number of POSH complaints in the Board of Directors report. Also important is other anti-discrimination policies such as the equal opportunity policy, which is especially for persons with disabilities and transgender individuals. And this aims to ensure fairness in hiring, promotions, and workplace inclusion. There is also the HIV and AIDS policy under the applicable law in India to spread awareness and to support workplace safety and health. Lastly, the data privacy policy also helps safeguard personal and sensitive employee information and ensures compliance with India's evolving data protection regime. On the other side, we have good to have policies. These are not legally mandated but are essential for efficient HR practices and consistent employee experience. For example, it includes leave and holiday policies, performance management policy, separation guidelines, grievance redressal framework, and information security, as well as anti-bribery policies. Next slide. Now, the common employer pitfalls, one of the most interesting part of the session. Uh, let's look at these common pitfalls which we see employers, especially the multinational corporations or foreign headquartered companies who have operations in India, continue to face. We have captured top 5 commonly observed mistakes. The one which is most important is employee or personnel misclassification. And this is one of the most frequently addressed issues for employers who have headquarters overseas and who are not accustomed with some of these very niche, nuanced issues which companies in India tend to come across from time to time. Employers may incorrectly classify employees as contractors, consultants, or interns to save on statutory costs. But under Indian law, the substance of working relationship prevails over labels. If someone works full time under your direction, they will likely be treated as an employee. And that triggers obligations like provident fund contributions, payment of gratuity, and statutory benefits. Misclassification of employees can lead to potential litigation risks. penalties, and even the obligation to make back wages payments. Another important point is one size fits all, which is a commonly adopted process by human resource teams. So India has both federal and state specific labor laws, a uniform employment policy which applies across offices across state jurisdictions may overlook regional variations, especially around holidays, the shops and establishment rules, or even outsourced workforce requirements. Similarly, trade union activism and level of government scrutiny and actions varying from state to state are an important point which continue to be missed out when you take one size fits all approach. Employers must localize policies and processes to each location to ensure compliance. The next one is improper handling of sexual harassment cases by global teams. POSH compliance, as we call it, is non-negotiable under Indian law. Issues arise when global compliance or legal teams make an attempt to investigate harassment complaints from India instead of the internal committee which is mandated to inquire into these allegations under Indian law. Now, not only is this a compliance failure, but it can also invalidate the findings and invite reputational damage. Every workplace with 10 or more employees must have an internal committee, and any complaint of sexual harassment raised by a woman, even through whistleblower channels, should exclusively be inquired into and addressed by the internal committee as per the processes which are provided for under the POSH Act. And this holds good even if the company has a more robust internal investigation protocol and a well experienced team in place. So, if any such alternate investigation team takes up sexual harassment cases filed by women, either of the disgruntled parties may approach the competent court to set aside the decision which is rendered pursuant to an investigation which was carried out by a team which is not the internal committee. The other important point is extending global policies without local adaptation. So global handbooks often include policies that may not align with Indian laws. For example, at-will termination, non-compete clauses, or limited grievance redressal processes. Blindly extending such policies can cause friction amongst workforce, confusion, and even render parts of them unenforceable. Localization is the key. Weak exit and termination processes, which is inclusive of improper handling of employee exits, especially termination, can backfire, unlike the US, which provides for at-will employment. India does not recognize at-will employment as a concept. Termination must be in line with contractual notice periods or the statutory protection under laws like the Industrial Disputes Act, especially for workmen. And this would include giving prior notice, paying severance compensation, and other relevant exit payouts. So with this, we come to the end of this session. Moving over to audience questions. Over to Vinay.
Great. Thank you, Anshul, for that really interesting presentation. I liked how you gave in a very a capsule format. You were able to sort of capture some of the key issues that we often find in our practice and which our clients obviously face. Now, there are a few questions that I think have been put up in the chat. Maybe I'll start with at what stage of the India entry project can foreign investors start hiring employees in India? We need personnel on the ground to help with initial setup, including incorporation of Indian entity. Can we engage them as employees till the time the Indian entity is set up?
Uh, Now, this is a very common scenario we see when advising foreign clients who are making an entry in India. They want to hit the ground running, especially when they do not yet have a legal entity incorporated in India. And if there is no Indian entity, foreign investors technically cannot hire employees as employees of the Indian company simply because it doesn't legally exist yet. So there are few options they can consider. Hire the India-based individuals as consultants of offshore entity. Engaging them as employees of the offshore entity is prohibited under foreign exchange control regulations, and it also creates a higher permanent establishment tax risk for the offshore entity. So engaging them as consultants may carry a PE risk, but this risk is far lesser in a short-term consultancy agreement scenario. The second and relatively safer route is to hire them through a professional employer organization, a PEO or employer of record. These are licensed Indian companies that can legally employ the staff on the behalf of overseas corporation until the local legal entity is set up and is operational in India. This gives flexibility, compliance, and avoids PE risk to a larger extent while still allowing the team to begin work on incorporation, vendor outreach, recruitment, etc. So, yes, you can have boots on the ground before incorporation, but how you structure that is crucial. And always access very clearly your exposure to tax and regulatory risk during this interim phase.
Thanks. Yeah. The tax risk is a key one there to sort of look out for. The next question is, can employers opt out of providing statutory benefits if they offer better discretionary benefits?
Answer is no. Statutory benefits are non-negotiable. You cannot contract out of it, and these must be provided to eligible employees regardless of what other perquisites are offered to them. And discretionary benefits can supplement, but they're not a replacement for statutory entitlements in India.
Got it. I think this next question is something that we've been asked a lot in recent times. The question is, what are overtime regulations in India? Our staff in India are highly skilled and there are no fixed work timings. They can work as per their schedules. Their employment contracts provide that their salary is all inclusive and they will not be entitled to any additional amounts even if they are required to work for additional hours in a day or on festival holidays. So, is that feasible?
Now, uh, so that's a very good question. And I would say the understanding is largely misplaced. It's a misconception which is commonly seen in India because people presume that highly skilled workforce who have flexible work timings are not entitled to overtime wages. Now, that is not true. Overtime pay in India is primarily governed by labor statutes like the Factories Act for manufacturing units and state-driven shops and establishment legislations for non-manufacturing units. And under these laws, any work which is done beyond 9 hours in a day or 48 hours in a week, or even on public or festival holidays, typically qualifies as overtime, and this is paid at twice the ordinary rate of wages. But here is the nuance. Entitlement to overtime depends on the employee's categorization. So whether the person is a workman or non-workman, because workmen are entitled to overtime, whereas for non-workman category or managerial category employees, the statutory overtime provisions are not mandatory. So the employee's skill does not really determine his eligibility for overtime, but it is whether he has managerial or supervisory skills uh, that determine his eligibility. Even though the non-managerial or workman category employees have a flexible work schedule, if they are required to work for more than 9 hours in a day or 48 hours in a week or on public or festival holidays, they will be entitled to overtime pay, and this is a statutory entitlement. So You cannot really opt out of it. And I'll quickly recall one of the matters we were advising on. It's a very interesting one where we were addressing a few queries from a large US-based fintech firm expanding its engineering team in Bangalore. And their employment contracts had a standard language. Salary is inclusive of any and all hours worked, including nights, weekends, and holidays. Now, the issue arose when an engineer resigned and demanded double pay for working weekends and late nights over 6 months. Uh, the establishment was surprised. The salary was generous, fixed, regularly paid, but this was a wake up call for them. And on review, we found that while the employer's title was lead developer, their actual responsibilities were technical and hands on, which qualified them as a workman under Indian law. Uh, and that made them entitled to overtime under the statute, regardless of what the contract said. Now, we successfully settled the matter out of court, but the lesson was clear. In India, the substance of duties overrides the title. So we regularly help clients audit their job roles and restructure their contracts to ensure compliance, especially where high skill doesn't necessarily mean managerial under Indian law.
All right. No, thanks, Anshul. Thanks for that practical example as well. Um, we have a bunch of questions. So the next one is, can employers have 24 by 7 operations in India? Are there any special conditions or permissions required in this regard?
Again, a very important one, and the most common operational questions we hear from global clients is, can we run 24/7 operations in India? And this is especially relevant for sectors like information technology, business process outsourcing, and global customer support, logistics, and healthcare companies. The short answer is yes, but it comes with conditions. India does permit 24/7 business operations, but there are state-specific regulations and compliance conditions. The primary laws that regulate these aspects are the shops and establishment legislations, which are enacted at the state level. We have already covered this point, but just to give a recap, they have rules that can vary depending on where the office or facility is located. You may also need to comply with the Factories Act if one is operating a manufacturing unit. In many states, to operate 24/7, employers have to obtain an exemption or a special permission under the local shops and commercial establishment legislation. Now, this typically involves applying to the state labor department. Uh, Even in a 24/7 setup, individual employees are still protected by the limits on working hours. So, the maximum 9 hours per day and 48 hours per week until overtime is paid, the mandatory weekly day off and shift timings, all these must ensure minimum rest intervals. So, also historically, women were restricted from working night shifts, generally between 7 p.m. and 6 a.m. But this has also changed. Now, most states in India allow night shifts for women employees, subject to some specific safeguards, such as provision of safe transportation, CCTV surveillance, security personnel as escorts, and written consent of the concerned employees. Now, this is especially crucial for information technology and information technology enabled services and hospitality sectors. Uh, States like Karnataka, Tamil Nadu, Maharashtra, and Telangana have more liberal policies for IT and knowledge based sectors. Some even provide blanket exemptions from certain provisions of shops and establishment legislations, particularly for IT companies, allowing 24/7 work without really requiring annual exemptions from the competent authority. And with that, I think quickly I will recall another, I would say, case study. And this was a global client of ours. setting up his Indian entity in Gurgaon, which is a hub for multinationals operating their GCCs and global capability and customer support centers. They plan to run a 24/7 customer support operation with night shifts starting in July 2025. However, they were clear that night shifts would be carried out remotely. No one would be in office unless absolutely necessary. So they had spoken to a local consultant and they were advised that from a risk mitigation perspective, it is best if they apply for the night shift exemption. And when they approached the labor authorities, the authority refused to grant an exception unless the client submitted proof of having engaged transport providers or security personnel for the night shift, a requirement that made no sense if the office was empty during night hours. And when they came to us, we advised that requirement to provide transportation facility to women employees to and from the workplace or deployment of security personnel on site during night shifts would be irrelevant in a work from home concept. So the spirit of law is focused on women's safety during night shifts, not to enforce infrastructure related compliance when there is no applicability or relevance of it. So to the extent the women employees consent to work in night shift or are engaged as per the prescribed daily and weekly work hour thresholds, and they're appropriately compensated for working in the night shift, including payment of overtime, there are no safety issues. The clients would be in strong defensible position should any questions be raised by labor authorities. So it's a good example of how Indian labor law is still catching up to flexible work models, but with the right legal interpretation and internal controls, compliance can still be achieved without the unnecessary red tape which companies in India may often face.
Great. Uh, Next up, we have a few questions around terminations. Maybe I'll club a couple of those together. The question is it legal to terminate an employee in India without notice? If we are to terminate the services of an employee for unsatisfactory performance, should I still provide notice pay and statutory severance? Maybe you can couple both of these together and take it, Anshul.
No, absolutely, I think very valid and very important question. As I said, Indian law does not recognize at-will employment. Uh, Termination must be in line with contractual notice periods or statutory protections under the laws like Industrial Disputes Act, especially for the workmen category employees, the non-managerial personnel. Now, this includes giving prior notice, payment of severance compensation, and sometimes even seeking government approval in case of larger manufacturing establishments. So, unilateral or sudden terminations can be susceptible to challenge in courts and may also result in potential reinstatement orders or monetary compensation. So we see many cases where clients proceed with at-will termination basis their overseas employment contract templates, which are executed with India-based employees, which many a times results in issuances of legal notices and also long-drawn litigation before various labor authorities. And on the question of termination of service of an employee for unsatisfactory performance, again, a valid point because in many instances, uh, people tend to equate performance based exits with those which are based on cause emanating from an act of misconduct. Now, this is again a common pitfall where we see multinational corporations struggling in India. We regularly are asked this question: if it's poor performance, why do we pay notice or severance? Now, unless the termination is for gross misconduct and supported by a proper internal inquiry, the organization must provide notice or salary in lieu of that notice and also pay statutory severance if the employee qualifies as a workman. And if it's not termination for misconduct, Indian law doesn't really lay emphasis on why you terminate. The rules would apply regardless of that. So even if poor performance is the reason, it's critical to follow the due process. Uh, Document the performance issues thoroughly and ideally conduct performance improvement plans before termination of an employee. Uh, provide notice period or salary in lieu of the notice, and pay the severance compensation. So we recently had a case where underperforming employees were being let go, and the employees resorted to chat GPT to understand what their rights were, and came to the company with a very well drafted claim of statutory severance compensation. Now, the company had to finally disburse such payments and make policy changes to avoid any such non-compliance or claims going forward. So, this is the key. Don't just equate poor performance with acts amounting to misconduct.
Yeah. Thanks for that. I think one more linked question in that context is practically how easy is it to implement a reduction in force exercise in India? What is the legal process and what are the industry best practices to follow?
Uh, sure. So, there is no straight-jacketed response to this question, but implementing a reduction in force in India, it requires careful planning. Uh, we cannot call the process difficult or easy, but the due process would involve a notice period or payment of salary in lieu of that notice, statutory severance compensation to eligible workmen category employees, and of course, settling all the statutory and contractual exit dues. That includes earned leave encashment, gratuity, prorated bonuses. And there is also a statutory requirement to follow the last in first out principle for selecting impacted employees. But this can be deviated from in certain cases. For implementing reduction in force in manufacturing units with over 100 workmen category employees, uh, I have mentioned in the session also, prior government approval will be necessary, which is not the case for non-manufacturing establishments. So this is equally important to note. And some of the best practices would include allowing the employees to prefer a voluntary exit instead of a unilateral formal termination to essentially avoid any stigma from a future employment opportunity standpoint, and offering a severance compensation which goes beyond the legal minimum to maintain goodwill, and also offering few non-monetary benefits like extended coverage on the insurance front and even outplacement services. Sort of for a smooth redundancy exercise, companies need to plan ahead, document everything, and of course consult a counsel early on to manage both compliance and employee relations related issues. So redundancy exercises also entail immediate cash flow for employers. So this is also an important point which needs to be factored in.
Right. I think since we are pretty short on time, I'll take one last question. Maybe around we are a multinational company with a robust global investigations and compliance function. Can members of such a team be appointed as third party observers or advisors to the internal committees under the POSH Act?
This question is this question is very similar to a recent matter where we have advised a multinational client with a strong global investigations and compliance team, and they wanted to leverage their experts as third-party observers or advisors to their internal complaints committee under the POSH Act, thinking this will strengthen the process. But here's the catch: the POSH Act is very clear and quite rigid in this regard. Complaints must be handled exclusively by the internal committee under the POSH Act with strict confidentiality and no room for external observers or advisors. Now, allowing global compliance members to sit in unofficially or even observe proceedings could tend to jeopardize the entire inquiry process, exposing the procedure and decision to legal challenges by the parties. So, what did they do? Instead of observers, we advised the company to co-opt a compliance team member as a formal IC member. And this is something which has provided the statutory requirements being met, like having at least half the members for being women, including an external member. Now, this way, the compliance expert can guide the committee on procedural aspects without influencing the outcomes, keeping the process lawful and robust. So it's a perfect example of balancing global governance ambitions with strict local legal frameworks.
I think that just about wraps it up. Uh, Thanks. I would like to thank Anshul for sharing his expertise and experience with us today. I thought the presentation was very well structured. Outstanding job, Anshul. Thank you for that. After the webinar, we will send to you a copy of today's presentation, materials, summary notes, and a link to the webinar recording. You will also separately receive a request for your feedback on the webinar. Please take the time to send us your feedback, comments, criticism, and even compliments. The form will take less than a minute to complete, so we request that all of you fill it. Thank you for your attendance today, and we look forward to being with you again at future Investing in India program webinars. Thank you so much.
Thank you.